and say, on this evidence, I should not be arrested. If the magistrate then considers the prima facie evidence to be sufficient to arrest him, will say, yes, you can arrest him and he will not be released on bail. Right? But this should only be done through a procedure that is reasonable, consistent with Article 21 of the Constitution. So that's what it says. Procedure established by law. This is no procedure. What you have here in Section 35 is no procedure at all. It is the subjective satisfaction of the police officer when he receives a complaint which he believes to be credible, on which basis he comes to the conclusion that there is reasonable suspicion, and the complaint itself is reasonable. Right? So the first thing that this government should have done was to scrap this procedure, because there is no such procedure in the eye of law, which is reasonable. That's the first issue. The second issue is that previously under 167 of the Code of Criminal Procedure, you could take a person into custody for a period of 15 days. But the 15 days started from the date of arrest. Now, under the new code now, the cumulative number of days, that is 15 days, can be spread over, instead of the first 15 days, can be spread over to 40 days in the case the charge sheet is to be filed within 60 days, and 60 days in case the charge sheet is to be filed within 90 days. So what will happen, though the law also says that this doesn't prevent the magistrate to grant bail, but the bail will never be granted for the simple reason that the investigating authorities will say that, look, sir, give me remand for 2 days, and the balance I will take later, right? And if the accused says that, look, grant me bail, he says, how can I grant you bail? The matter is still under investigation. So after 1 month, he will ask for another 5 days. So still there will be left a balance. Then after a month, he'll ask for another 5 days. So in other words, now the law will be implemented in such a manner that a person arrested on suspicion will never get bail for 60 days, right? Or 90 days as the case may be. In other words, you make the law far more oppressive than what it was earlier. Then, as I was mentioning to you, there is this provision, 173 of the code. That's very interesting. It says, every information relating to the commission of a cognizable offense, irrespective of the area where the offense is committed, may be given orally or by electronic communication to an officer in charge of a police station. And if given orally, it shall be reduced in writing by him under his direction and be read over to the informant, and every such information, whether given in writing or reduced in writing, shall be signed by the person giving it. By electronic communication, it shall be taken on record by him on being signed within 3 days of the person giving it, and the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may by rules prescribe. Now this now, if you look at 183, says any magistrate of the district in which the information about commission of an offence has been registered may, whether or not he has jurisdiction in the case, record the confession or statement made to him in the course of an investigation under this chapter, or under any other law for the time being in force, or any time afterwards before the commencement of inquiry or trial. So therefore now you can investigate an offence, right, anywhere in India, and the magistrate anywhere in India, outside the area where the jurisdiction of the magistrate lies, can record a confession. So all the investigation shall be done outside the jurisdiction of the police station where the offence is committed. And that evidence and investigation then will be presented with a charge sheet to the magistrate where the trial will take place. So the investigation will be done somewhere else and the trial will happen somewhere else. This is both unconstitutional in terms of violation of the federal structure and even otherwise because it's not a reasonable procedure established by law. These are some of the major flaws as far as procedure is concerned. Now, if you look at the Nyaya Samhita, that is the penal code, that has some very interesting provisions. Let me just give you some examples. There is a provision called organized crime. That's 111 of the Nyaya Samhita. It says, any continuing unlawful activity, including kidnapping, robbery, theft, extortion, land grabbing, contract killing, economic offense, cyber crimes, traffic of persons, drugs, weapons or illicit goods or services, human trafficking, prostitution or ransom by any person or a group of persons acting in concert, singly or jointly, either as a member of an organized crime or on behalf of any syndicate, by use of violence, threat of violence, coercion, intimidation, or any other unlawful means to obtain direct or indirect material benefit, including a financial benefit, shall constitute an organized crime. Now, what is organized crime? Means a group of two or more persons who act singly or jointly. So if two people get together and commit theft, it is organized crime. If two people get together and grab land, it is organized crime. If two people get together and threaten somebody with violence, it is organized crime. And then what is important here is the definition of continuing unlawful activity means an activity prohibited by law, which is a cognizable offense punishable with imprisonment of 3 or more years. So any such activity which is punishable with more than 3 years done by two persons is organized crime. Then economic offense is also defined as offense includes criminal breach of trust, forgery, counterfeiting of banknotes, hawala transactions, fraud or running away a scheme to defraud several persons, or doing any act in any manner with a view to defraud any bank or financial institution or any other institution or organization for obtaining monetary benefits in any form. So this kind of economic activity, offense, is also organized crime. So in fact, any form of human activity in which the action of two persons or more amounts to the commission of an offense punishable with 3 years or more becomes organized crime. Now see the consequences of it. Whoever commits organized crime, if such an offense is resulted in the death of any person, will be punished with death or imprisonment for life, and shall also be liable to fine. In any other case, be punishment with imprisonment for a term which shall not be less than 5 years. So if two people snatch a chain, the minimum is 5 years. But which may extend to imprisonment for life. If two people commit an economic offense, 5 years or imprisonment for life. If two people threaten somebody, intimidate somebody, 5 years or life imprisonment. And whoever attempts, abets, conspires, or knowingly facilitates the commission of an organized crime, or otherwise engages in any act preparatory to an organized crime, shall be punishable with imprisonment for a term which shall not be less than 5 years. So a preparatory act also for the commission of an offence. If two people get together and say, "Ke kal hum yahan chori karenge," so that's minimum 5 years. Now, and then any person who is a member of an organized crime syndicate. What is organized crime syndicate? It's 2 or more persons. So if there are, say, 4 persons who are together, but 2 of them do not actually do anything, the other 2 do, then the law says any person who is a member of an organized crime syndicate shall be punishment with imprisonment for a term which shall not be less than 5 years. So I have not done any act. An allegation in the complaint is that I am a member of the organized crime. I am not involved in that offence. 2 others are involved in the offence. Allegation is that I am also part of that. I will also be punished for 5 years. Now that complaint can easily be made. Names can, no. In India what happens is, if the police itself add names, so the fellow will not get paid, he will be in custody, he will say, "I was not a member of that." They will say, "But no, we believe you have reasonable suspicion that you are a member of that organized crime, and you'll be inside for 5 years, you won't get paid." Whoever possesses any property derived or obtained from the commission of organized crime, or proceeds of any organized crime, or which has been acquired through organized crime, shall be punished with imprisonment for a term which shall not be less than 3 years. So if somebody does any chain snatching and goes and sells it and gives it to another person who is found with it, he will also be inside. So these are some extremely liberal provisions, I must say, that the Home Minister and this government has thought of. Even more serious now is the definition of a terrorist act. This really takes the cake. Whoever does, it's 113 of the Bharatiya Nyaya Sanhita, called BNS. Whoever does an act with the intent to threaten or likely to threaten the unity, integrity, sovereignty, security, or economic security of India, or with the intent to strike terror or likely to strike terror in the people or any section of the people of India by using bombs, this, that, and the other, or are likely to cause death or loss or damage or destruction to property. Now you see, just think of protests. Protests made, farmers' protests made, lead to destruction of public property, or rail loco yatras, or something like that, which lead to destruction of property. That's a terrorist act. If it leads to loss or damage to or destruction of property, or disruption of supplies of services essential to the life of the community, damage to the monetary stability of India by way of production or smuggling, or circulation of counterfeit Indian paper currency or any other material, or damage to destruction of any property in India, or in connection with any intended to be used for the defense, or in connection with any other purposes of the government of India, or any state agencies, or overawed by means of criminal force or show of criminal force or attempts to do so, or causes death to any public functionary, or attempts to cause death, detains, kidnaps, abducts, or whatever, commits a terrorist act. So now protests, dharnas resulting in destruction, damage, loss would be terrorist acts. And whoever commits a terrorist act, if it results in death of a person, will be punished with death or life imprisonment, or in any other case, be punished with imprisonment for a term which shall be not less than 5 years. And then, any person who is a member of an organization which is involved in a terrorist act, and you know what the terrorist act now is, shall be punished with imprisonment for a term which will extend to life. And whoever harbors voluntarily, conceals or attempts to harbor or conceal. So if the protesters are there and they go and sleep in the neighborhood in somebody's house, the neighbor will be deemed to have harbored those terrorists, right? And that neighbor will also get at least 3 years imprisonment. So if you provide food to those protesters who are protesting against the government, you will all be part of that and all be liable to punishment.